There are so many more issues in business that lead to money. The owner, the member in the LLC, the shareholder in the small corporation is not necessarily looking at that.
Yeah, 35 years to build your wealth, and one problem could take it all. Now,
each financial decision is not in a silo by itself. It has to be looked at how it relates to something else in your plan. And most people are not looking at the big picture.
So this is John Smallwood, and we are back today on the Money Isn't podcast. And I have a really special guest, as we do frequently. But if you're a business owner or thinking about forming a business, forming the right structure, having the right entity might be one of the most important decisions that you're going to make. I have a very seasoned attorney with me today, Tim Lyons. He's a partner and co-chair of a business litigation department at, what's the name of the firm, Tim?
Jardim, Meisner, and Susser.
Welcome to the podcast.
Thank you, John. It's a pleasure to be here. I appreciate the invitation.
Me too. And I really look forward to this. Now, one of the things that's really interesting is you are a certified civil trial attorney since 2005.
Correct.
What does that really mean?
Well, it's basically an accreditation to a litigation attorney. You have to qualify with a certain amount of jury trial experience, and then you have to study and basically almost take like a second bar exam.
Oh, wow.
Specifically with regard to trial issues, the evidentiary codes, and things like that. And the purpose the bar has that and the state has that. And civil trial is one denomination. You can get the same accreditation if you're a criminal trial attorney or if you're a matrimonial attorney in those subject areas.
Interesting.
And the reason is to not only specialize the attorney's knowledge and experience, but to make a good faith representation to clients or people who may need an attorney in that area, that this is a person who specializes in it and in that specific area, mine being civil trial. And has had the experience and has the knowledge and the expertise. So, that's the person you want if you're either have been sued into a civil matter or if you're going to be a plaintiff.
Okay. So the reason I have him on today is not because he went to Notre Dame or Seton Hall Law School. Okay.
Okay.
But to really talk about the business structure, right? Because I've been doing what I do for 35 years, and it's sort of like every business owner that we work with, they don't have the right entity. They maybe don't even have an entity at all. They're operating as like a Schedule C. They're exposing themselves to unnecessary liability and extra taxes.
Right.
And the biggest issue is they don't even have really good books in operating, which leaves them wide open.
It does. And that's about, if I were to split my practice into percentages, which is kind of hard to do, but for purposes of this discussion, about 15% of what I do is business or company formation, and then also governance. If I have a client that comes to me and wants to form a company, or as you had just indicated, may have the wrong formation in stake.
Like this guy, who's our recording guy. Yeah.
Believe it or not, some people still, and you may come across this, Sean, some people still operate as sole proprietors.
Yes, often.
And from a legal perspective, that is a huge danger zone due to liability, and they don't realize what their liabilities are. So,
which is that Schedule C on your tax return, if you're questioning what he's thinking about, okay?
And
so why is that?
Because you're exposed personally to any liability in this business that you're running. And I hear clients sometimes tell me, well, it's my business, I'm the business, and you don't get that protection. And they may be a new company, or they may, fortunately, have never had any legal issues in operating their business. But part of my counsel to clients like that is to troubleshoot, and to troubleshoot problems that may come down the line and insulate them and give them protection. So even if it's just a single member who's been operating as a sole proprietor for an X amount of time in whatever business they may have, I always counsel them to either get to a LLC formation, a limited liability company formation, or a closed corporation, maybe subchapter S
or
corporation,
C, or
right? Somehow to protect themselves, and explain to them, and they fully grasp and easily grasp the concept of the corporate shield and protection against not being sued, so people aren't suing and taking their assets that John Smallwood and Smallwood Investments have worked very hard to develop for them.
Yeah, 35 years to build your wealth, and one problem could take it all. Now, if you can you share like a horror story of like somebody that didn't think they had any liability that had ultimate?
Right there, yes,
conceptually at least.
Yes. There's this goes back several years. There's a gentleman who, and it's kind of a Jimmy Stewart type movie almost, had a hardware store business in northern New Jersey, worked very hard, was very successful, was a sole proprietor, never had any issues, had ostensibly a slip and fall in the area of his store, didn't have sufficient insurance, and the company got sued. And he had thought, and that's when he came through my door, because his company got sued, his hardware business got sued, and all of his personal assets were exposed because he was personally exposed because he operated as a sole proprietor. In the normal course, and I told him after the fact, unfortunately, had you come to me earlier, we could have put it in an LLC or in a small corporation, and the LLC would have been sued. And if there were no, as you know, if there were no assets or appreciable assets in that LLC, he's still protected for everything he's ever worked for and have earned and put into his Smallwood investment account.
Smallwood Wealth Management is the lead sponsor of this podcast. You have an opportunity to have a free, no obligation conversation with one of our qualified advisors. Go to smallwoodwealth.com, schedule a call, or call us at 800-797-1000 and get on our calendars. Did he own the building also?
He did not.
See, that's the people like, oh, I don't own the building.
Right.
They're going to sue the building owner,
right?
Not me.
Right.
Well, last I checked, we sue everybody.
Well, right. The kitchen, with all the developments in the law as it continues to subspecialize, the kitchen sink approach is always going to be there.
Yeah. Because like, who has the biggest exposure? You don't know until you throw everything on the table. You're like,
correct.
Oh,
correct.
Sole proprietor, bang! This is great.
And plaintiffs' attorneys try to squeeze a little bit of money out of everybody to let them get out of the case.
Yeah.
Typically. In that situation, that issue also came up because he doesn't own the property, but he was managing and operating the location where the slip and fall fell.
Triple net lease, probably.
Right, in the store.
Yeah.
Correct.
Responsible for all the maintenance, responsible for everything. So the building owner was probably able to defray it.
The building owner, in that case, not to get into too much detail, the building owner tried to defend it based upon terms that were in the lease.
Interesting. So this is why I wanted to have you on, right? Now, before we go a little further, the podcast is Money Isn't. And I know when you first heard it, you were thinking about like, what the hell is that?
Right.
What does that mean to you? Like when you think of that, like what does Money Isn't mean to you?
Money isn't, that phrase to me, what it came to me is, there is so much more, and in my personal beliefs, and then obviously my professional experience is there are so many more issues in business that lead to money, that are affected and turn into money. But the owner, the member in the LLC, the shareholder in the small corporation is not necessarily looking at that. They don't see that on the landscape. Yeah. And we go back to the formation and choosing the entity and then setting it up, and we'll get into corporate governance and the necessity of keeping your books correctly in a minute. But if they don't see that, because you know as well as I do, John, they're busy working. Yeah. They're busy running their insurance business, running their hardware
I don't
store.
have time to talk to you right now.
Right. What do you mean there's a potential legal liability on a certain issue? So it's an education process. So money isn't, as you mentioned it, the first thing that comes to my mind as an attorney in the work I do is the client that doesn't see where the money is or where the claim may be, and to protect them. And then also, where can they manage their company? Where can they form their company and maybe make it more lucrative to them? And that's where a lot of this work I do in the beginning of the client relationship is. You have to sit down with your accountant. I have to work with your accountant. If you have a financial professional such as yourself, we should consult them and bring them into the loop. Because at that time, it's not only to form the company correctly, it's to protect what the person has personally from ever being subject to litigation.
Yeah. Let's jump into, okay, I either have a business or I'm thinking about starting a business or starting a new business.
Right.
What are my options and what am I thinking about? Like, what are my decision metrics?
You're thinking about, first of all, where are you going to operate? Are you going to be in New Jersey, solely in New Jersey? Or are you going to be, do you want to be regional or national? And is that the ultimate game plan? So it really comes down to, that's the first introduction, as I'm sure it is with you, with your clients. Is there a business plan? Okay, you tell me you want to open this company in a certain line of business with this name, and I have this great idea. But do you have a business plan? What's it going to look like?
Yeah, where are you going to be 5 years from now?
Right.
10 years from now?
Because similar to what I think you do, that's going to help me recommend to them how they form it, okay?
Right.
You don't want to be a sole proprietor. I am not a big proponent at all of partnerships because the owners still have personal liability with them. So I usually suggest a corporation, a small corporation, or an LLC. And one of the very first questions I have after I hear about what the idea is and all the energy that the client has is, who's involved?
Partners.
Right. Who are the
siblings?
Right. And that's partners is the magic word, right? And that's where I stop the conversation and say,
Is that where you say, no, I don't want you as a client?
I will.
I'm just kidding. I'm kidding.
And I say, and that's a perfect jump off point. And it typically happens to tell the client, we need to start to talk about the proper terminology because I need you to start thinking about the proper terminology.
Yeah.
So in the legal sense, a partner has a completely different distinction than member and shareholder. So where are we going with your idea and where you're with your business? Are we forming a limited liability company? Is it going to be a single member limited liability company? Meaning, are you going to be the only owner for now? Well, I want to make change. Okay. Changes down the line, as you had indicated, John, a 5-year plan. What window are we looking at and what are we going to form? Because we can always amend and change and things like that. So how many owners are there going to be? Who is involved with this? One of the other things I try to fish out is anybody else involved in this? You're telling me it's your idea. You're telling me it's the company you want to start. Did your college friend help you come up with this idea? Is this a brainstorm in a garage you've been working on for a while?
Are you licensing a piece of technology from a company,
right?
That could go away or whatever it is?
Or are you going to want to claim ownership to that so you can license it out?
Correct.
So that's all on the landscape we have to feather out with the client. And if they're going to be a single owner limited liability company, for example, that's a separate operating agreement than a multi-member. If you have more members, then you're going to want provisions for buyouts, or you're going to want a separate buy-sell agreement.
Retirement, disability, death.
Right, because when the main issue, and this will get into business divorces if we talk about those a little bit later, if you have multi-member owners, or if it's a shareholder situation in a corporation, you have to start to look at what happens if this business marriage falls apart. If you have, say, 3 other members or 3 other quote-unquote common term partners, what if one gets sick? What if one goes through a marital divorce and moves away and wants out of the company? What if one becomes disabled? Or
wants to shift shares to their spouse in their divorce decree?
Right.
Whoa, we don't want that.
Right, exactly. So you want provisions for that, and it's everything. So you have to help them figure out what they're doing, get from them what they're doing. Then you can make a recommendation on what business formation are you going to use, at least initially. You can always change it. You can always modify that. And the hope is always, even as the attorney, is your business is going to take off in 2 years, 4 years, 5 years. It's going to become this expansive dream that you want it to become.
2, 3, 4, 10 million, $100 million company.
And I
billion-dollar company.
I always tell my clients in those situations, why do I have to get an accountant? I said, you're hoping your problems are accountant related, because that means you have a tax issue. And if you have a tax issue, to me, from what I see, 8 times out of 10, 9 times out of 10, it means, how am I going to treat the gains? How am I going to treat the profit? So I said, having financial professionals involved from the inception is just good business, and it's good legal work, but it's a positive sign.
Like in the view of business, and from my own personal experiences owning multiple businesses and having, my dad and I were partners for like 25 years.
Great.
And we had started off with like an S corp.
Right.
And one of the issues came along the way. Like, we had this handshake partnership that when we started the entity, we were 2 sole proprietors. And I said, we got to stop doing this.
Right.
And we formed a corporation. And we said S election, because at the time we were doing equal production.
Understood.
And the thought pattern was, hey, we'll split the overhead and then kind of take, we'll take base salaries and then, we'll distribute profits. And in my mind, in our minds, it was 50-50.
Right.
And a couple of years later, the accountant's like, you guys can't do unequal distributions because you each own 50% in the S Corp.
Right.
You can't do it that way. And we're like, what do you mean we can't do this? And then you had to expose yourself to, you had to increase taxes or increase, bonus compensation to
Right.
equalize it. Right. And then you ended up paying more Medicare tax and, all kinds of crazy stuff. And it was like, that wasn't what you thought about. Right.
Right.
So you learn from those lessons. So it's sort of like, where are you going? Like, if you're starting with 3 partners, how do the 3 partners get compensated? And like, I've seen it with, technology companies where, you got a salesman who is driving it. And then there's 2 partners who are, one's the CFO and one, operations guy. And now everybody's splitting up, a third of the revenue. And the
Right.
guy who's selling is like, what do you mean?
Yep.
And now you just like, you got to think about where you're going. And it's like the entity choice, like if you're going to sell the company in a very short period of time, C Corps have really interesting
Yes.
tax treatment in
Yes.
the moment, which
Yes.
looks like we may have that for a while.
I have a client who's in that. He's an older man, and he's had a very successful business with one's a cousin and one's a brother. And for tax effect, they were told to transfer it to an LLC. Well, you can do that. He's got to wait 5 years.
Yeah.
And at the time, I think he was between 75 and 80 years old when he wanted to sell. So he had to wait that time frame. So as we're talking about,
The built-in gains tax.
correct, you need to flush all of that out, because if you have other members, you think it's great, other people will help me build the business, we're all on the same page. Well, are we all on the same page? Or does John want to be out in 5 years for some reason? He wants to buy an island in the Bahamas. And I just love the work, and I want to keep going and going and going and pass all my assets down to my family. 2 completely fine, both great plans, 2 completely different plans. Well, what I see in a typical situation is when that 5-year point hits that the one person wants out, there's a problem.
I've seen that way too many times.
Right,
They get super successful. Guy goes to Florida and he's collecting 50% of the profit and he's doing 20% or less of the work.
Right.
If that. He's like, oh, yeah, I'm on the golf course. I'm going to be calling in later.
and he still wants his full take from the company.
Yeah.
Yeah.
It's like, well, we built this.
Right.
We didn't build this.
Right.
And so like the operating agreement, let's talk about, so I just want to frame this for a second.
Sure.
So we've got a sole proprietor, we got a partnership, we've got a limited liability corporation. You can have a limited liability partnership.
You can.
A medical practice needs to be something different than a limited liability corporation, I believe. Right?
That I'm not sure of. I don't specialize in medical practices.
Right. So there's a different version there. But then inside of the LLC, you can choose a taxation that's going to be partnership or S Corp.
Correct.
You can elect those. Then you have the corporate structure, which would be C Corp.
Right.
You would have a S Corp election, 1120 versus 1120S.
Effectively, correct.
Right. So you have all these different options.
Right.
Right. Which are really revenue and the quantity of partners.
Right.
Right. Certain entities don't apply once you go over a certain amount of partners.
Correct.
Right?
25. Correct.
25.
Right.
Magic number.
Right.
Which is why the law firms are structured in certain forms, right? Also.
Correct.
Like, because you hit a certain amount of partners, if you're in one entity, you can't actually do it the other way.
Exactly.
Okay.
Exactly.
So you're making these decisions. The single most important decision in that is not where you are today,
Right.
but it's where you want to go.
It's where you want to go, and it's also explaining to the client the roadmap we have to go down, which is what you and I are talking about right now. What entity, so it's really fact-finding. What is this company going to be? Who's going to be involved? What are the intentions of the people being involved? What discussions have you had with regard to all the potential terms and conditions and issues you're going to come across? That's really where the client's eyes kind of typically open up and say, like, I didn't know all of this. Well, that's why we're meeting. And that's why you have me. And that's why if you don't have one, you're going to get an accountant. And if you don't have one, you're going to get a financial advisor, because these issues have to be addressed right now. So then once we get to that point, once we figure out what we think your company wants to be, and I try to favor LLCs because of what you had just spoke of.
Yeah.
You get the beneficial tax treatment, right? You don't get taxed at the corporate level, so it's single taxation, not double taxation.
Yep.
But you still get the benefits of the corporate form, because the LLC is basically the hybrid of the partnership and the corporation. So you still get the benefit of the corporate shield and the protection.
The asset protection.
Right. And you still get the benefit under the corporate statute of management, certain management of operations and the way you can structure that. So that's really why people favor, and even accountants, in my experience, kind of favor LLCs. It's not the perfect fit all the time, but it's a pretty wide berth of what you can do and what you can kind of squeeze in there. And then we start to get to the point of, how are you going to run this company? Who are going to be the officers? What's going to happen? And that's really the corporate governance that you and I have talked about before.
And let's dive into the corporate governance, because I think, that is one of the most let's just say, people forget about it.
It's underappreciated. It's underutilized. And I can tell you, as we're going to discuss this, the warnings I give to clients, sometimes they don't listen to it.
So let's just say I form an LLC.
Right.
What do I have to do?
Well, what you should do to protect, and the reason you follow the corporate form is that's the way, in the eyes of the law, you keep that corporate shield protection.
Like dotting these I's and crossing all these T's.
Correct. If you start operating too loosely and you don't have meetings and you don't keep your books appropriately, and depending upon what you do with the because if everything's going well in the company, depending upon what you're doing with the bank account, you and your two other members, maybe we're taking money out. I'll take some money out of the account. I need some now. I'll put it back in next week. And there's a history of a commingling that's going on. Under the eyes of the law, claims could be brought against you for personal liability because you abandoned the corporate form. The term we use in the law is piercing the corporate veil. Because you, John Smallwood, operated your company more like a sole proprietor.
Interesting.
You abandoned the corporate form. And there's a history of that. Now, that's a fact-specific decision a judge or a jury has to make, but that's the exposure you have in that.
So when you do that, you just basically opened up the entire creditor world.
Right. You've exposed yourself to losing that corporate shield protection where nobody's going to be able to sue you for liabilities of the company, of the limited liability company. Now, keeping those things together also is, and this comes even up more frequently, is a good way to manage the company vis-a-vis you and your members, okay? Because we call them business divorces for a reason. It's similar to a marital divorce, similar reasons the relationship falls apart. And there's just as much emotion and there's just as much financial rancor that goes on between members as there are with marital partners. So keeping the corporate governance is a way for my client to not only follow the corporate form, but to maintain their rights in the management and the operations of the company. What, as you had said, you're going to have an operating agreement. What does the operating agreement say? Yeah, what are your rights?
What are some of the things that people miss in their operating agreements?
We talked about the biggest one I see is there's no provisions for a disability situation. There's no provisions for a buyout. There's no collaterally incorporated buy-sell agreement or anything like that.
No methodology for valuing the company.
Correct. And that's when you get down to business divorces, that's one of the big issues, the business valuation. And
I love this term, business divorce. I mean, I hate it, but I think it's, and I wanted to have that conversation with you, but I think this is the appropriate time. So I've created this company. We've been running it for, let's say, 5 years. Business owner. And all of a sudden, you guys are unhappy with each other, which I've been doing this for 35 years. I encounter a lot of partnerships and entities with 4 or 5 partners, and everybody's mad.
Right.
All right. And somebody wants out. that if you're not managing your books properly, you're exposing yourself to wide open valuations and wide open terms and
Right.
people stalling.
It's going to be a very detailed, complex, and expensive litigation, even if it's just you and one other partner. Okay, because the first question that becomes is, does somebody want to leave? Like, what's the reason for these issues coming up? Is it a divorce? Does somebody want to leave? Or did I see that you're taking money from the accounts? Or did I find out that you as my member are taking our clients, funneling them to somebody else and getting kickbacks? Happens a lot in the construction industry, right? Or in the sales industry. Happens a lot. These things happen. You don't realize it when you're driving down the road, but these things are happening every day in business.
Money getting embezzled by partners.
Correct.
Fake. I've seen literally fake PO agreements or, like bills from entities. And you pay $10,000 to this company 4 times.
Right.
Or who's that company?
I see situations where, there was this inherent trust because it was a marriage. And then they find out that the member, let him run the bank accounts, and we were making money. We were doing great. I saw the tax returns. I'd see a P&L maybe every quarter, and it was great. And what you didn't see is the bank statements, and your member's been, your partner or your member's been pulling money out of the account every month. And so when that arises, the question becomes, do you want a divorce? Because there are situations, somewhat limited in my experience, where, they don't want to disturb the machine, right? Because the machine is printing money for them. Right. So, but I really don't like you now. And I really, really don't like the fact that you're taking money or you're taking clients. So what do I do?
Or it could just simply be you were really productive and now you're not.
Right.
Like you were a fabulous partner,
right,
who was adding value to the firm, and the value has stopped.
Right.
Is there a way that can be put into a good operating agreement and continually reinforced?
Yeah. The way you do that and address those issues is either in the operating agreement or you incorporate a buy, sell, or a compensation agreement. To say that if someone's performance can be measured in monetary metrics, and that's how they're going to be compensated, then you put that expressly in the agreement. The best thing you can do is have your attorney detail everything either in the operating agreement or in an addendum to it or an incorporated agreement. Because if you have to go to court, it's not going to be, well, we were sitting down on November 13th, 2024, and we agreed to this. That means nothing, as you can imagine. Right. So that's why it's all about preparation.
You need minutes.
So when we get into corporate governance, and when you get into business divorce, you're looking back at corporate governance. I know there were only 2 members, but why didn't you have meetings? Oh, well, we were on the phone all the time. I don't care. I told you and recommended every month, every quarter, if it's 20 minutes sitting down at the office, sit down, have minutes of the meeting, what was discussed. Were there client projects or customer projects coming up that we discussed? That way you have a record to show a judge or a jury, this is what we discussed, this is what was agreed to in the minutes, or even then you have assigned resolutions that you put in your corporate book. And that's all the documented evidence you have as to what was going on with the company. And then you can prove what the fraud was or what the theft was. And therefore the reason may be why they shouldn't get the value they're seeking to get out. Because I talked before a little bit about if the partners want to stay together simply because the machine's just too big and too good to them. But 95% of the time it's somebody wants out and they just want as much value as they can get.
Right. They're like, oh, companies are selling for, EBITDA 10x.
Right.
And they're like, I want my 30% out at the 10x.
Right. And as you may know, there are 3 major methods for business valuation. Appraisers will come in and, like any expert in any legal case, they'll tell you what you want, what you want to hear, what you want said on behalf of your client. So the business valuation part of it is a very, very big aspect, typically in most business divorce cases. There are a lot of issues like marital divorces where things are personal and people want to vent and details like that. But so the business divorce really is how do you protect yourself in that situation if you don't see it coming with your member is corporate governance. being astutely. And if that means spending a little bit more time in the office, spending a little bit more time in the company, it's something you should definitely do. It's a prudent way to proceed. And if the answer, and I tell clients this all the time, if the answer is, I put enough time into the company, that's going to take too much time. Okay, well, unfortunately, I hope I don't ever see you on this issue, but in 3 or 4 years, if you come to me with this litigation problem, it's going to cost you a lot of money one way or the other.
Yeah. So this get my head spinning in a couple different areas, right? So if you're a business owner and you're listening to this and you're thinking about like what's going on in your business for a second, like,
right.
Are you actually, first of all, do you have the right entity? Okay. Mm-hmm. 2, do you have the right governance in place and are you documenting it?
Right.
All right. Because it sounds like to maintain the corporate structure, I should have a documentation process as to not pierce the corporate veil, but I should also have some sort of accountability from the agreement.
Correct.
Even if you're a single member, LLC, you're the sole 100% owner.
Right.
You still need to do these things.
And sometimes people who come in and I form them as sole member LLCs, well, I really need an operating agreement. Like, no, you should have that. It's a typically a simple form, obviously. You should have that, and you should keep a corporate book. Resolutions maybe of large things that the company does. And even as a sole member, that helps if you go to sell it. Then you have a corporate book of what you've done with that LLC over the years. What type of customers have you had? What type of projects have you worked on? What if you're a construction company or in the building industry, what projects have you built on? What's your customer list and all of that? So typically, as you know, a client will be like, well, I'm very, very astute at keeping all my business records together as far as clientele, customer lists, contacts, et cetera. And I have drawers full of that. Well, you should have a drawer full of accounting records, but legal records too. It's never, ever, ever going to hurt you. And really all it's going to do is just take a little bit more of your time.
Yeah, like
I'm sorry, John. It puts them in the right mindset, I believe, too.
Because I think if you're thinking about creating a really good structure, like if you're a C corporation and you don't have good documentation and your goal is to sell the corporation, what I'm seeing a lot of pitfalls now is the buyers are coming in saying, we don't want to buy your stock. There's too much liability.
Yep.
So we're going to buy your assets.
Right.
And the sole reason that you were, that, what is it, $10 million excluded from gain in a C Corp sale if you sell the stock.
Right.
But if you sell the assets, you're paying all the tax. And how many, I just see that problem coming up because there's no way to document the skeletons in the closet.
There isn't. And you can go back and have resolutions entered and try to, quote unquote, clean up the records. But in the situation you just mentioned, the buyer or the buyer's team is going to come in and they're going to see that those resolutions are post-dated anyway.
Yeah.
So number one, how accurate are they? And was the real intent of that just to try to make the company look better internally to us? And so the same risks are probably going to apply.
Right. So, and then I see this problem happening a lot, and I think you could speak to this, is I'm building a business and I have a really good employee. And some reason I see this happen all the time. I'm going to give him 5-10% of the company, and then they regret it.
Right.
Like, why is that? Why does that happen? Why do people do that? And what could be better alternatives? And what are the pitfalls in giving somebody that's really not an entrepreneur ownership?
Right. So you have a few options from a business perspective how you want to handle that situation. If you want to keep that employee, obviously you could put compensation packages together, whether put them on a full commission agreement or something like that. So
phantom stock plan.
Correct. So,
phantom bonus.
So you might have other contractual agreements with that employee. Now, if you have that, where are those agreements going to go? Those are going to go in your corporate records because if you sell to somebody in a few years, they're going to want to know who this employee is. Does the employee still want to stay with the company? What's the agreement the company has with him or her? So you could do that. You can offer them small percentages. Small percentage of stock ownership, I think my experience is people take that on as far as buying into that simply to try to get a dividend or a distribution revenue, because otherwise it gives you no authority with the company.
It gives you potential liability based on the covenants of your banking agreements and stuff like that.
It does.
And
sure.
how you sign lease agreements, whether you're personally guaranteed them.
Sure.
Yeah.
And what it does give you, even as a minority member or minority shareholder, is you have a right to vote, unless the operating agreement says differently.
Right.
So
voting versus non-voting shares.
Right. Not to turn this into a figure eight, but
but that's what we do.
Yeah, yes. So the owner may want to bring that agreement on with the employee, but you may also want to simultaneously amend your operating agreement to control what rights that employee is going to have or not have.
Yeah.
And the argument you make to the employee is to say, you're buying 5 or 10%. I can't have you have some great voting right, and then you're going to upset the apple cart of what we're doing.
Right.
We're successful primarily because I've built the company and you've helped me, and I'm trying to reward you here.
Yeah.
So it can be done, but again, it has to be detailed in agreements to be protected, because otherwise you run the risk of an employee like that going rogue and thinking they're more valuable, or ultimately thinking they're more valuable than they may be, and they want more. They think they're entitled to more compensation or more voting rights, or they want to be involved in management, and really start to spin like a little bit of a hurricane inside the company.
And then I've seen it where, business is making, I don't know, $2 million, but on paper.
Right.
In S corp profit, and now the guy's going to get 200, but they're paying down lines of credit, so there's no cash.
Right.
And they're getting hit with this $200,000 taxable income, and they're like, the company's only distributing, the tax.
Right.
And then it's like, well, why aren't I getting all that money? Where's that? Now you got to go in, you got to open up the books. And my position is, partners should be partners if they add value in a way that you don't. You don't need two people that have the same idea who left the company. Do they really add value to each other?
Unless I agree, and they have to complement each other.
Yeah.
The only distinction or difference I see in that is if the newer quote unquote partner or member, you acknowledge and you want them to come on to replace you, maybe because you're in what you view the sunset of your business or the sunset of your career for whatever you want to do.
What do you I want to go backwards for a second.
Sure.
And we talk about buy-sell agreements all the time. How many companies do you think actually have a really rock solid buy-sell agreement addressing death, disability, and retirement?
I can't give a percentage, and I don't mean to be flippant about it, but I get a lot of work because people don't have that.
That's good. That's what I want to hear.
Right. So, it's not good for them, but litigation is what it is. So nobody really wants to be in litigation, but it's a kind of a necessary evil of business. The direct answer is not a lot. And you can see almost when you represent someone who's in a company, whether it's an engineering firm or an insurance firm, you can see pretty much if they're sophisticated from an organizational standpoint. You expect to see those things. But if it's more loosely held, and the loosely held companies sometimes are even much more lucrative. Yeah. But if it's more loosely held, then you don't expect to see those, and you don't see them. And that typically causes issues of the fact that those terms have not been agreed to is the first part. The second part is what you had indicated before is the valuation then. Yeah. The two members may, even through their attorneys and through their counsel, they may come to an agreement on what we want to do or what we should do or what our real agreement was. But somebody, has a value that's completely different from what you think.
Years ago, I was working with a large corporation that was unbelievably successful, right? It was really, really good. And, we have business valuation software and things that we can do, but, we're not doing the business valuation for a court of law. We're doing it for buy-sell agreements and understanding what the key performance indicators of the industry are and where you got to make it. And I took a couple of years of the tax returns and I said, the company's worth $120 million.
Right.
And, you got 5 partners and you're all equal partners and, everybody needs $25 million worth of insurance, and we need key man on that guy because
Right.
he's the lead guy.
Yep.
And I got thrown out because I just wanted to, life insurance is part of that solution.
Yes.
And the company's only worth $5 million each. I'm like, so you're going to do an agreement for $5 million. You die, your spouse and they'll buy out your $5 million. And 10 days later, they sell the company for her share would have been 25.
Right.
How is that? What kind of litigation are you opening yourself up to there?
Well, you're huge litigation, and it may or may not go anywhere as the plaintiff because you're going to say, "Where's the $20 million?" Well, no, you
agreed to 5.
Right.
You just effed your family.
and that get right. And
Technical term. I want to throw that out. I'm not using the real word.
Obviously, inadvertently, unintentionally, and that's exactly what happened. But you have to tell the executor of the estate or the widow or the widower of you have a problem.
Yeah.
And you're right. Maybe you should be getting another $20 million, or your husband or wife should have gotten another $20 million. But that's not what they agreed to. Yeah. And now we go back to documenting everything. If those agreements are fully documented and the attorney who represented the decedent was wise and,
corporate governance
in writing, instructed and advised to do this, you should follow, the Smallwood valuation. That's the one you should work off of. Yeah. And for other reasons, maybe they're, maybe the company's hiding money, maybe they're hiding cash on the side. You don't know what these particular members may be doing outside of the sphere of what you're told. But yeah, it gets into litigation, and you think about, there are attorneys who would think about litigation knowing that's not going anywhere, but saying, let's start a lawsuit, see if we could squeeze some more money out of them, which is not the way I operate.
And the company did sell for north of the 120, right? And it was I was validated, but you're trying to do, I'm trying to do really good work. You're trying to do really good work. Every business that gets started, you're starting the business to be successful.
Right.
You're starting the business to get unique tax benefits. You're starting the business to grow a legacy. Mm-hmm. And I see a tremendous amount of even single member, business owners, and there's no succession plan.
Right.
So here's this beautiful business that, you're dead or you're disabled and the business is gone.
Right.
Somebody goes, oh, I'm in the business. I'm your lead, whatever. Let's just go take the clients and go start a new business.
Sure.
There's no governance that's going to stop that from happening.
That's right.
But if you put together an agreement and said, hey, Bob, you're my succession.
Right. So from your example,
you're my succession plan.
You have to have that practical succession plan, right?
Yeah.
This is what I want to do with the company because I'm getting older, or my family has a history of cancer or heart disease, and God forbid that happens to me. I need to have a plan. I need to have a safety plan. I need to have insurance. I need to have disability provisions, et cetera. And then it gets back to what we've spoke of this morning, which is, how do I do that?
How do I do it?
You talk to John Smallwood or you talk to Tim Lyons, and they work together and they put a plan together for you. Now, you touched on, I think inadvertently a little bit before, something that does happen more frequent than I wish it did, is in these situations, I'll sit down with the client and I'll put in a plan together of what to do, document what formation we should start, et cetera. I don't want to do it that way. I don't need to do it that way. I don't need to. So right
based
there,
on opinions and biases and stuff that's in their brain that they were hanging on
or
to.
what they've done before, and how they may want to operate their company, and they don't want people looking into their company, and they don't want this is too involved. This is a simple business. We've made a lot of money and have become very wealthy by doing this. So we're just going to keep the train on the track. Okay, I hope some of these pitfalls I've tried to troubleshoot never happened to you, and I'd imagine you probably have similar situations like that where people just don't follow your counsel, and you hope the bomb never goes off on them.
Or I see people, and I see people get to a point where hey, they hit late 50s, early 60s, and they're tired,
right?
And they're like, and they kind of let the business kind of just
trip away,
as opposed to going, hey, I could get some really good employees here and we could redo this business and transfer ownership over time, do an installment sale, and really make this thing valuable, because like you built it and then you got tired and now it's kind of like deteriorating on the back end because you're not focused. Like you're comfortable, but you're leaving money on the table that is valuable money.
Right. And you're losing that opportunity. I've seen that happen a few times where I'll be in a discussion with a client and be like, and they'll describe exactly what you had just said. And then I went to such and such business coach because I was going to sell the company. And they told me, it's not that valuable. It's not worth the $25 million it was 5 years ago.
Because your books and your records and your accounting's all
and that's not what
up.
the market is anymore. And whether it's a real estate company or whatever, that's not what the market is anymore.
Multiple was 10x, now it's 2.
Right. So then they're in a situation of, okay, well, from a business perspective, what are you going to do? Put the legalese aside for a minute. Are you going to re-up on your company, try to build it up, and maybe sell it off to somebody, or try to put together some type of a succession plan, and meet with an accountant or meet with Smallwood Investments, and get back on the beam?
Yeah. So we talked about a lot of things today.
Mm-hmm.
We talked about business divorce.
Right.
We talked about the right entity. We talked about having a vision of really what this company is going to go to, right? If you had to say to the business owners, the single most important decision, the first decision, what are you making? What's the first decision?
The first decision, I would recharacterize it as an instruction. And coming up with the term business divorce over doing this work the last 20 years, I've developed another term that I've had several judges tell me they like it and they haven't heard it before, is the ostrich effect. So just as in a marital divorce situation, even from the get-go, don't be an ostrich. As silly as that sounds, don't put your head in the sand. Be involved, be engaged, and plan going forward. Have your head up, not only with regard to the day-to-day business, but have a head up with regard to the financial planning, which things your firm would be involved in, and the legal planning. And part of that, avoiding that ostrich effect, is don't walk out of Tim Lyons' office thinking, I have all the agreements I need, I'm good for the next 5 years or so. You have to constantly nurture it, and you have to constantly stay with it. So the first point is, let's find out who you are, what your business is, and what you want to do. We can then start down the road of what you're going to form, how you're going to operate it. And I guess one of the more important things we spoke about today is who's going to be involved and what are their expectations.
Yeah.
And again, expectations is the thing I really push clients when they're operating their businesses. Have those meetings, have those quarterly meetings, those monthly meetings, even if it's just 1 or 2 issues or something, because you need to stay engaged with your other owners. Because I see when you're not engaged like that, that's where things risk maybe diverging.
The ostrich effect is like putting synapses in my brain right now. Like, oh my God. So I encounter this all the time.
I can imagine you do.
Right. But the thing that I think that gets me the most is business owners don't know how to read their profit and loss. They get to tax time and they dump a bunch of crap on their CPA, and then they get numbers back and they go, oh, write that check.
Right.
I think if I was, and I do this, right, but if I was really thinking about it, and it's really hard to get business owners to do it, you would actually want to, in the shareholder meeting, you would actually want to incorporate a set of P&L governance so that everybody's really understanding, hey, our rent went from X to Y. Why? Okay.
Right.
Our profitability's up or down.
Right.
Right. We have depreciation. We have all these kind of things that we could be benefiting from. How do we tweak the business? Because I believe there's like 8 or 9 areas of every profit and loss statement that you can go in and modify and adjust and adapt and make the business so much more profitable.
Right.
But if you don't understand how to, if your books aren't updated weekly,
right.
And I encounter, hey, we're recording this. Let's just say it's mid-November, which it is.
Right.
I have books through May. Like, whoa, it's November.
You're a little behind pace, right?
I'm on extension.
Yeah.
I have a spreadsheet. I have a whiteboard where I keep stuff, right?
Right.
It's like, Oh, okay. So I want to frame this like you're going to start a business, you own a business, you've got partners, you don't have partners, you don't have an operating agreement, you haven't updated anything in a while. How does somebody reach out to you and say, okay, Tim, I need to get a consultation?
Right.
Where do they reach you?
They reach me at my firm, Jardim, Meisner, and Susser. Can be reached. My email is the easiest way to reach me, tlyons, Lyons, at jmslawyers.com.
That's pretty easy.
Our office is down, the office I'm in is down here in Tinton Falls. Our main office is up in Morristown, right on the edge of Florham Park.
Oh, nice.
So we're throughout New Jersey, and I'll travel to meet clients to help them any way I can. I try to make myself available to meet them any way I can, and I'll start anywhere where they are in the equation. Whatever questions they have, if they're starting out with the genesis of their business, that's great. If they're further down the line and they have a suspicion, or they're listening or watching this podcast and they realize, like, everything's okay right now as far as I know, but boy, we don't have our agreements lined up. We don't have this as tightly wound up as John and Tim are telling me I should have. That's something I can help them with.
Or I'm
too.
a sole proprietor and oh my God, I realize now I should have an entity.
Right.
And I want to start. Okay, reach out to you and you can
Right.
help them make the right decision.
I make the right decisions, and people should know at that point of the equation, I always suggest if you don't have an accountant, you need to get an accountant. And if you don't have one, you probably need to get a good insurance representative.
100%.
And depending upon what your financial situation is on a personal basis, you need to meet with Smallwood Investments too.
I appreciate that. The ad is running at all times.
Yes.
Right?
We're all in a service business, John.
We all are. And to me, like, the business success always comes down to, like, you could tell you're really interested in the quality of your work. Right? Our success comes from the quality, and it comes from the quantity of people that we share it with.
Correct.
Which is one of the reasons that we do the podcast, right? And I think this conversation today just hit the tip of the iceberg.
Well, I was going to tell you that off camera, but yes.
Right? And not today, but I'd like to have you come back and let's take like a couple of different really bad or good things that we want to focus on and say, let's really go down it so that we can really add value to the listeners. And
I would love to do that.
good. And if you're listening to this, comment on what you want to hear, right? Because if we get the comments, we will direct
Definitely.
the conversation to what you want to hear. If you haven't already, subscribe to Money Isn't on YouTube or Spotify or Apple, iTunes, whatever it is. Apple, I was going to say Apple Music, but it's really the podcast one.
Okay.
Go to Smallwood Wealth and you can find out more about what we do there. But the number one thing that if you're a business owner, you need a macro plan. You need a team that Tim discussed. You need the attorney. You need the insurance professional. You need the financial advisor. You need the accountant. And those people need to coordinate and come together on your behalf to work for you.
Correct.
That's what I love.
Correct. And there's two things I like to add. One is if you meet with that team and for some reason you as the business owner decide, oh, I don't really need that right now. Okay. But that professional's out there and that at least your attorney or your financial advisor thinks it's a concern enough that you should meet with them. And the second thing is everything we talked about today. One of the most important things is, again, it's a business marriage you hope doesn't end in divorce. So people get caught in trust. Well, look, we were doing so well. I trusted him. I saw him every 2 weeks and I didn't know these things were going on. Well, if you do the proper governance, it takes a little bit more time, a little bit more effort, well worth it. And if any member or partner ever complains to you, we don't need to do this, that's when the red flag should go up. So if everybody's in it and altruistic, then, they should be willing to go along with all the corporate governance things we recommended today.
Awesome. This is really great. Thank you. I'm going to reach over and give you a handshake. That's awesome. Thank you.